here's a standing rule that sounds simple. You can only sue to protect your own rights, not someone else's rights. No third-party standing. But like everything in the standing doctrine, there are exceptions, and they're applied selectively. The biggest exception, the close relationship rule. If you have a close relationship with someone whose rights are violated, you can sue on their behalf. The textbook example here, doctors and patients. The case Singleton v. Wolf in 1976. Missouri said Medicaid wouldn't pay for abortions, so doctors sued, arguing the law violated their patients' constitutional rights. The state said, wait, these are your patients' rights, not yours. They should sue, not you. The Supreme Court created an exception. They said the doctor-patient relationship is close enough. Doctors have a financial stake, they understand their patients' needs, and here's the key part. Patients might not be able to sue themselves. Abortion is stigmatized. Women might fear being identified. They might not have the resources for a lawsuit. So they let the doctors sue on behalf of their patients. Sounds reasonable, but watch how this plays out. The court says you need two things for this exception. First, a close relationship ensuring the plaintiff will vigorously advocate for the third party's rights. Second, some practical obstacle preventing the rights holder from suing directly. But close relationship is whatever the court says it is. Parent-child, obviously close. Doctor-patient, sure. But which doctors and which patients? The courts have been weirdly specific about abortion providers. Sometimes they have standing, sometimes they don't, depending on which restriction is being challenged. And here's what's wild. The exception was basically created for abortion cases. Courts recognize that forcing pregnant people to sue individually was just impractical. By the time their case gets through the system, they're no longer pregnant. The injury becomes moot, so doctors could sue instead. But now, post-Dobbs, watch how this exception gets strangled. Doctors in states with abortion bans want to challenge those laws on behalf of patients who can't get medically necessary care. Will courts suddenly decide the relationship isn't close enough? That doctors don't really represent patient interests? The exception reveals something uncomfortable. Courts decide certain people can't speak for themselves. Abortion patients supposedly need doctors to sue for them, but patients sue in other medical contexts all the time. Why are abortion patients different? The doctrine treats them as uniquely unable to assert their own constitutional rights, but it's selective. When beer vendors challenge the drinking age on behalf of young customers, courts sometimes allow it. When parents challenge school policies affecting their kids, standing is easy. But civil rights organizations trying to sue on behalf of a minority community they serve, suddenly the relationship isn't close enough. Third-party standing isn't about protecting people who can't sue, it's about controlling which cases get heard. The close relationship exception sounds like it opens courthouse doors, but it's just another tool for judges to pick and choose which constitutional violations they want to address.